I didn't hear you. Can you repeat that?
Yes, sir.
Okay. The other thing that's somewhat different is that Ms. Patel is also appearing remotely. So she's in her office. She's not with you, and you have a right to have your attorney by your side in case you have any questions. But she's going to be appearing from her office. Are you comfortable proceeding having Ms. Patel connecting remotely this way?
Yes, sir.
If you need to speak with her in private, we can make that happen. It is easy to move you and Ms. Patel into a private breakout room where your discussions will be confidential. So if you need to do that, or if Ms. Patel needs that, I need one of you to let me know, okay?
Yes, sir.
Great. So Ms. Hall is going to put you under oath, and we will go forward with the plea. If at any point you cannot hear what's going on, Mr. Turner, wave your hands or do something like that. I noticed your screen just went black, so we're going to wait till we can see you again, and then we'll get started. I think we're good from this end. Next, there he is. All right, stop playing with the camera. All right, Ms. Hall, when you're ready.
Thank you, Your Honor. Mr. Turner, can you please raise your right hand?
So I don't know if there's someone else from the jail on, but we're having some connectivity problems with One North. I don't see anyone else, unfortunately.
Judge, can you?
Says the bandwidth is low out at One North.
Judge, can you? Hear us, Judge? To see that? It's good. It's good.
So
Judge, can you?
we can sort of hear you, but it's real choppy, and the picture keeps coming in and out. It tells us there's bad bandwidth at One North. Do you have a point of contact at the jail? I don't know that that's really your channel to be running. Okay. They usually have a second person on who isn't on the screen, who's sort of managing whatever's going on out at the jail, but there's now no one on. Maybe they're going to reconnect.
You gonna stick around, sir?
No, I think we're good. We know how to find you. Appreciate it. Well, while we're waiting on the jail, tell me, Mr. Franklin, what are we doing with Mr. Fortson today?
It's going to be a plea.
All right. Mr. Robinson needs a lawyer. That's what we're going to talk about. Huh, an 03 case, plea and arraignment. Who is handling Nelson Evans?
I am, Your Honor, and Ms. Patel. And there will be a no process from the state, Your Honor. I will submit that paperwork today.
Okay. And then we've got Mr. Rogers, and it lists Brian Hobbs as his lawyer. Who's handling Mr. Rogers' case? Mr. Franklin, okay. Are we going to be able to work through that today, or is this one that we need to have an evidentiary hearing?
No, Ms. Besa reached out to me yesterday and she did some background work and we were able to work out an agreement.
Okay, great. Well, thank you guys for coordinating that. So assuming we can get the jail up and running, we've got plea on Mr. Turner, plea on Mr. Fortson. We'll meet Mr. Robinson, figure out what he wants to do with lawyer. Does Mr. Evans know Ms. Patel what's happening, or are we going to want to break the good news to Mr. Evans?
Yeah, notified him maybe 5 days ago about the state's intention to null toss the case. If he happens to be on the floor, I think it'd be nice to hear it.
Sure. Okay. Good. Well, we'll do that, and then we'll get Mr. Rogers. So we should be able to motor through this if we can reestablish our connection. Ms. Nelson has reached out to the sheriff's office, and hopefully we'll get something soon.
All right, Judge, we're back. We had Wi-Fi issues, connections.
Okay, thank you so much for scrambling. We appreciate it. Wow, you moved Mr. Turner all the way from 1 north to 6 south. That's a fast elevator. All right, well, Mr. Turner, if you've got a little motion sickness, let us know. All right, we're gonna get back on to where we were. Ms. Rivers, you good to go?
Yes, sir.
Okay, so Mr. Turner, you were about to raise your right hand and Ms. Hall was going to swear you in. That's what we're going to do now, okay? There it is.
Mr. Turner, do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Bryant Lee Turner. Bryant Lee Turner.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
37, 11th grade.
And are you able to read, write, and understand the English language?
Yeah.
Do you understand that you've been charged with the following offenses? Burglary in the first degree and criminal trespass.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead and if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Patel, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
I waive.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Waive for the purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
You waive.
Ms. Attorney, have you been arrested for these charges?
Yes.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
And Mr. Attorney, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum maximum for burglary in the first degree is 1 to 20 years to serve, and the maximum for criminal trespass is 12 months to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of for the count of burglary in the first degree, a sentence of 5 years to serve 2 years, commuted to time served, special condition that you enter into drug court. For count 2, the criminal trespass, just 12 months probation. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. You understand?
Yep.
Do you understand this plea may be used to enhance sentencing or other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yep.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yeah.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
Ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Sir,
Can you repeat your answer, Mr. Turner?
Yes, ma'am. Can you hear me?
Yeah, why don't you ask the question again, Ms. Hall? It's sort of the critical question of the whole process.
I will. Mr. Turner, is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yeah.
So, Mr. Turner, the record's not going to reflect the way you responded there, but you paused, you weren't sure, and you said, yeah. There's something that we need to work through because
Can
no
I
one's
talk?
trying to force you through this process.
Can I talk to my attorney?
Yes, you can.
Okay.
So let me do two things here. And breakout rooms. So I'm going to move you and Ms. Patel into a breakout room. You or one of the detention officers near you will need to get you into that breakout room. Once you're there, we cannot hear what you're saying. Only Ms. Patel can. When you're done, you need to come on back, okay? I'm going to send the invitation right now.
And we're ready whenever you are, Your Honor.
Okay. Mr. Turner, are you back with us?
Yes, sir.
Did you have enough time to speak with Ms. Patel?
Yes, sir.
Are you comfortable proceeding?
Yes, sir.
Okay. So the question that Ms. Hall had asked you is, are you entering the plea to these two counts, burglary and criminal trespass, because you are in fact guilty?
Yes, sir.
You are. Okay. You're comfortable moving forward?
Yes, sir.
All right. Ms. Hall, back to you.
Thank you. Mr. Turner, in indictment number 19-SC-171587, how do you plead to the charges of burglary in the first degree and criminal trespass?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Ma'am.
Thank you. Your Honor, had we proceeded to trial, the state would have proven that on July the 26th, 2019 at 7495 CAPPS Ferry Road, that's in Chattahoochee Hills, Fulton County. Officers responded to that location to a burglary in progress. When they arrived to the scene, they encountered a co-defendant at the scene coming from the back of the house. They did detain that co-defendant, put him in the back of a police car. Another co-defendant, Miss Jennifer Bastille, was also detained walking down the street not too far from the incident location. Officers, upon investigation of this burglary, they did locate the first co-defendant in his vehicle, items that came out of the house of the resident that they were on the property for the property they were on, and also burglary items from a previous burglary that had taken place. Officers also found inside of that truck a cell phone of the co-defendant, which led to Mr. Turner's arrest. Inside of the cell phone showed evidence that Mr. Turner was another person that was involved in the burglary that took place on that day. He was just not on scene when officers arrived. That is it. That's all the facts as far as the burglary. All of the items, Your Honor, were returned, so there is no restitution being requested in this case. And as far as the defendant's criminal history, he does have 4 prior convictions dating back to 2004. The most recent conviction was the 2019 conviction, which is the one that we're dealing with today for the revocation, the 2018 indictment. And he has 2 years, 8 months, and 1 day remaining.
Got it. So if I had arrived with the police at the scene in Chattahoochee Hills, I would have found Ms. Betzel walking down the street. And I remember her. I remember her plea. Mr. Mitchell is the guy who was sort of in the act, if you will. And then what you're saying is a review of the contents of Mr. Mitchell's cell phone got the police interested in Mr. Turner and indicated that Mr. Turner had a role in the burglary.
That is correct, Your Honor.
Okay. And the only open case you're aware of is the 18 SC case that you just mentioned with the almost 3 years left on it.
Yes, Your Honor.
Okay, thank you. Ms.
You're welcome.
Crawford, good afternoon. Do you have anything else on Mr. Turner or just the 4 priors we heard about?
That's correct. Just the 4 priors with the 1 open case.
Okay. When was the next most recent one? There's the 2018 that was a plea in 2019. When was the next most recent one?
Looks like it was 2011. That was out of Fulton County. I can give you the case number. It's 11 SC 103030. It was an aggravated assault and criminal trespass.
Okay, thank you.
You're welcome.
All right, Ms. Patel.
Thank you, Your Honor. Mr. Turner and I have known each other for a minute now. I had him a while ago, and then he had bench warranted. The goal back then was to try to get him into drug court, but to get him to enter from the street. He had a job doing landscaping in Palmetto, Georgia. And so at that point, we had gotten him out on bond, and we thought that he's one of the few clients who has really stable housing. He's lived with his mom for quite some time in Palmetto. Things obviously have changed a bit now since then. His mother is very loving and supportive, but I don't think that she's just a little too old to give Mr. Turner the eye and guidance that he needs. And speaking with drug court, they determined it would be best if they found Mr. Turner housing that would be closer to the program, one that would help him to report to drug court, but 2, they'll be able to have the watchful eye that his mother was not able to provide. Mr. Turner's always been motivated to work and to be active in obtaining employment. I will say that and I'm not trying to put you on the spot, Mr. Turner, but his education was a little overstated. He does have a lot of trouble reading and writing. I did have to, when I first met him, read the police report to him, which has created an enormous difficulty in Mr. Turner getting any job other than manual labor work. With that being said, Mr. Turner is fairly young. He's in his 30s, but you know, he has a very severe meth addiction that has pretty much quite aged him at this point. He's wanted help for it for a while. In a lot of ways, it was a blessing that he was picked up on this warrant because we can put him into the program directly, so there's not a concern that he's back out on the street. He also suffered at some point with an addiction with pills, but methamphetamine has been his biggest struggle in terms of dealing with that. With regards to the case, Your Honor, he is here to accept responsibility. I think that the evidence would have shown that Mr. Mitchell was quite the ringleader. He had a moving van with him that had a moving company logo. In Mr. Turner's eyes, everything seemed on the up and up, but he clearly didn't ask enough questions about how this man got this job. And why he didn't pick him up to take him to the job. He had Mr. Turner meet him there. Miss Betzel, it was the same thing where she was trying to get a ride to leave because she didn't even have transportation either. I think that I'm hopeful that being under the watchful eye of the courts is what Mr. Turner needs. I think that his mom, she's really tried everything she can to be supportive, but I don't think she's ever given him the push, and she surely could not afford any substance abuse treatment for him. I believe he's currently served 101 days, and then when he was previously incarcerated, he served 44 days. And so that, Your Honor, is how Ms. Hall and I got to our negotiated resolution to put Mr. Turner into drug court. I believe when we spoke about the probation revocation for his 2018 case, I don't have the balance written down, but Ms. Hall and I discussed revoking the balance and commuting it to time served so that Mr. Turner is just reporting on one probation case.
Okay, got it. Thank you for sharing all that. So, Mr. Turner, I got a couple questions for you. So home for you has been Palmetto for a bunch of years, is that right?
Yes, sir.
Okay, it sounds like the way we're gonna start with drug court is that we'll get you temporary housing. And I need to let you know when I say we, there are 2 drug court judges. I'm one of them. So 50-50 chance you'll be working with me in drug court. If you do, that's just a coincidence. It's not because you pled here or the case was assigned to me. They send every other case to me, and every other case goes to a judge named Judge Krause. So it may be that you work with Judge Krause, you may work with me. But we can provide temporary housing, and it sounds like that may make sense. It's closer, it's a different environment, but it's not permanent, and that's good news in a couple ways. It may be after you stabilize some and show yourself and the program that you can stay clean for 60, 90 days, not in jail, that it makes sense to go live with your mom. But transportation is always going to be complicated. And if you don't have your own set of wheels and a valid driver's license, it takes a minute to get from Palmetto to Hope Hall. So we'll work through that, but I wanted to make sure you understood that likely for the first few months in drug court, you'll be living in housing that drug court provides. Does that make sense?
Yes, sir. It makes sense.
Okay. That's just, I didn't want you to think it was permanent and you had to stay there for all of drug court. You actually can't, because we open up those beds to other folks who are transitioning from jail back into being in general circulation.
Yes, sir.
Working is a great thing, and you will be free to work consistent with the drug court requirements. So if you're working landscaping, that could go pretty well if you've got a flexible boss. Early on in drug court, the hours are focused more during 9 to 5, but if you do well and phase up, then the classes that you attend are all in the evenings, and then you can work all day long. But I just want to make sure that you may be interested and focused on starting to earn some money, and we never discourage that in drug court as long as it doesn't interfere with your drug court obligations. So just know going in, we can help you with housing. It's not permanent, but it can help out. And then 2, working is fine, but you can't have a 9 to 5 job Monday through Friday in the early to be a little more flexible than that. I'm going to accept your plea, Mr. Turner. I find that there's a factual basis for the plea. And I also find that your plea is knowing and voluntary. A knowing plea is one where you've understood the things we were talking about. And if you didn't, you asked to speak with your lawyer, which you did. And we set it up so you and she could have a private conversation. Are there any questions that you have right now, Mr. Turner, about any of the stuff we talked about?
Yes, sir.
Okay. A voluntary plea is simply one where no one has forced you to enter this plea or threatened you in any way, and you're entering the plea because you think it's the best way to move forward for you. Is that true?
Yes, sir.
Great. I'm going to sentence you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you are on probation after drug court, if you have a small problem, a technical violation, you and probation will work that out. But if it's something more serious, you get arrested again, or you get terminated from drug court, then a judge is going to deal with that alleged violation of your probation. I'm excited for you with drug court. It's a great program. I'll tell you, it only works as well as you put into it. So don't panic if on day 4 you relapse. Just don't run, because we will find you. And the next step, if drug court doesn't work, is inpatient treatment that you don't get to walk away from. And that may be where you got to be if it's a real, real bad addiction. But we often lose drug court clients because they relapse, which is what happens if you've got a serious addiction. But then it's followed by panic saying, uh-oh, I can't let them know I test positive. Come on in, test positive, and own it. Say, hey, I screwed up. I saw one of my buddies last night and we got high. And then we're going to talk to you about maybe you need to stay away from your buddy. I mean, maybe that's the issue. It's people and places and things like that. So please do give drug court a try. They're going to do a lot to support you. I think that's it. Here's how I'm going to sentence you. I think, Ms. Hall, that count 2 merges into count 1. The way the indictment is written, the criminal trespass is entering onto the property of Mr. Davis and Ms. Edison. And that's exactly how count 1 is pled, with the additional element of the intent to commit a theft. So I believe there's really only a sentence for count 1, and that 2 merges into it. Do you have any disagreement with that, Ms. Hall?
I do not, Your Honor.
All right, Mr. Turner, I'm going to sentence you on count 1 to a term of 6 years to serve 2 years with the balance on probation. And those 2 years are reduced to the time you've already served. So you will be released to the custody of drug court. You're not getting out today. You'll get out when drug court can come pick you up. They pick people up on Wednesdays, so it could be next Wednesday. But I'm going to put that in the sentencing order that you're being released to the custody of drug court personnel. But we don't risk we'll give you 4 or 5 days and then you walk into drug court. You go from jail to drug court for orientation, and then they'll get you to your housing. But they also have to make sure that there's a bed lined up for you at one of their housing options. I want to explain why I'm giving you 4 years probation rather than 3. What you and your lawyer negotiated with the state was 3 years. Drug court usually takes about 18 months, maybe 20. It may take a little longer for you because we may try to get you into some literacy classes as well. There is a component of drug court that typically involves doing some reading and writing, but we work with clients with all different backgrounds. And if there are things that you simply can't do because of your background, we come up with alternatives. You'll still benefit from the program and you'll get all the counseling and all the tools. You may just do less of the reading and writing part. But when we encounter clients who would benefit from some literacy programming, we sometimes try to get them in that as well. And that can extend the program a little bit. So I just want to make sure we have enough time on probation to get you through everything you need to get through. And that's why I'm giving you the 4 years instead of the 3. And the other reason is you were, of course, on probation for a burglary when this happened. And I think that's a reason just to extend things a little bit so that I have something to work with if, I hope it doesn't happen, but if things go off the rails and you walk away from drug court and you relapse, and then to support your habit and just get food in your system, you break into someone's house or a gas station or something, I would like more room with the probationary piece to work with. So that's my thinking on that. The last thing I need to make sure, if you were here in court, Mr. Turner, you would sign your indictment, which I'm holding right here, but you are off at Rice Street. Do you authorize me to sign your indictment for you?
Yes, sir.
Ms. Patel?
Yes, Your Honor.
And Ms. Hall?
Yes, Your Honor.
Okay. Ms. Crawford, do you need to get any information from Mr. Turner, or is the fact that he's going straight to drug court and they'll know his address because they're getting housing for him, does it work better that way?
That's correct. I don't need to get anything from him. We just need to do the revocation.
Okay, great. Great.
Okay.
So the last thing then, Mr. Turner, is in case 18 SC 163292, and that was your open burglary. What I'm going to do is revoke 8 months. How much time do you have, Ms. Crawford?
He has 2 years, 8 months, and 1 day remaining.
All right, that sounds very similar to what Ms. Hall said. So what I'm going to do is revoke 8 months and 1 day of your probation, but I will reduce that to the time you've already served. I will reinstate the balance, and I will add as a special condition of your probation in that case, and I need to go back to your other case in a minute. I will add as a special condition of your probation that you enter into and stay in drug court. Let me go back to the case you just pled to, the 19 SC case. Forgot to mention, there is one very important special condition of your probation in the case involving Caps Ferry, and that is that you enter into and complete drug court. That's a term of your probation. So if you are terminated from drug court because you run away from it or you get in trouble with some kind of new case, that would be a violation of your probation, and then we'd work through how we get you maybe a higher level of treatment than drug court provides. So I just said a whole lot. You have any questions about any of that, Mr. Turner?
No, sir.
Okay, Ms. Patel, anything else?
No, Your Honor.
Okay, and the basis for the revocation is the new conviction. Ms. Hall, anything else for Mr. Turner?
Nothing further from the state, Your Honor.
All right, Mr. Turner, I wish you the best in drug court, and I may see you in a few weeks if you get assigned to my docket, okay?
Thank you, sir.
You bet.
All right, next we have position number 3, Mr. Michael Fortson.
Thank you.
You're welcome.
Good afternoon, Mr. Fortson.
Good afternoon.
How are you doing?
I'm doing all right.
Good. So Mr. Franklin tells me that you are prepared to enter a plea in your case. Is that right?
That's right.
Okay. Well, the way that's going to work is that Ms. Hall, who's the prosecutor on your case, is going to put you under oath in just a minute, and then you're going to need to answer some questions from her and a few from me, okay?
Okay.
If at any time you cannot hear us or you don't understand what the question is, wave your hands or move around or something so we know, okay?
Okay.
Mr. Fortson, you have the right to be here in open court, but because of the pandemic, we're conducting some court business by having the defendants appear out at the jail. Are you okay moving forward there on 6 South rather than here in courtroom 8D?
Yes.
Okay. If you were here in court, I bet you Mr. Franklin, your lawyer, would be here in court as well. But because you're out there at the jail, he is dialing in from his office. Are you okay having Mr. Franklin on the screen rather than sitting right next to you?
He can be on the screen.
Yeah, he's there. Mr. Franklin, can you appear?
I'm here.
Okay. Can you see Mr. Franklin?
Yes.
Great. If you need to speak with Mr. Franklin privately, Mr. Fortson, let me know, and I'll move you into a private breakout room, just you and Mr. Franklin, so you guys can talk, okay?
Okay.
All right. Well, we're going to get started then when you are ready, Ms. Hall.
Thank you. Mr. Fortson, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
That's correct.
You may lower your hand. Please state your true, correct, and legal name.
Michael Fortson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medicine.
And what medicine is that, sir?
Cogentin.
And what do you take Cogentin for?
For sleeping.
Okay. Do you take it at night or in the morning?
Both morning and night.
Did you get it this morning?
Yes.
Okay. When you take the medicine, does it make you groggy or sleepy, or does it help you understand what's going on?
Both.
Okay.
Make sure you're aware of things.
Are you feeling like you're understanding what's going on now?
No,
You do not understand what's going on, or you do understand what's going on?
I do understand what's going on.
Okay, you don't feel like the cogentin is making things cloudy or foggy for you?
No, I just
Okay,
wanted to say I was sorry.
okay, we'll give you a chance to say that, okay?
Okay,
Thanks.
Mr. Forson, how old are you and how far have you gone in school?
I'm 24. I've been going in school for 5 years.
I'm sorry. I'm sorry. You said you were how old, Mr. Fortson?
34.
Okay.
And how far along did you get in school, Mr. Forson?
To the 10th grade.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that you've been charged with robbery by sudden snatching, robbery by force, 3 counts of simple battery, and 1 count of obstruction of a law enforcement officer?
yes,
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
yes,
Do you need more time to discuss this case with your attorney? Are you satisfied with his services?
yeah,
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, if any, for purposes of this plea only.
And do you waive moving forward on a copy of the indictment?
Yes, ma'am.
Mr. Forson, have you been arrested on these charges?
yes,
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am, we're not aware of any outstanding warrants related to these charges, although there is a probation hold, I believe, in Clayton County that I believe this incident to serve as the predicate for.
Mr. Forson, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
no,
With the robbery by sudden snatching and the robbery by force, they're both 1 to serve 20 years in prison, and all of the remaining charges, which are misdemeanors, the maximum is 12 months to serve. You understand?
yes,
Do you understand that this is a negotiated plea of guilty, which means the state will recommend a sentence of, for the counts of robbery by sudden snatching and robbery by force, 5 years to serve 2 years, credit for time served, balance on probation, special condition that you receive mental health evaluation and treatment if necessary, as well as limited use of MATA. Your Honor, we'll speak more in depth about that towards the end, as well as assigning a mental health probation officer as a condition as well. But the court does not have to accept that recommendation. The court can sentence you to the maximum on these charges and can, the court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. And Mr. Forson, the misdemeanor charges, the state's recommendation is 12 months probation. Do you understand?
yes,
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
yes,
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
yes,
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes,
Do you understand that you're not allowed to possess, do you understand that you're not allowed to possess or use a firearm while on probation?
yes,
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all of those rights that you're giving up, Mr. Forson?
Yeah.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
No.
So, Mr. Fortson, that's a tricky question, the way it's posed. What I need to make sure is that you are pleading guilty here because you agree, after you talked with your lawyer about it, that you actually did these things that the state is saying that you did.
So if I may interject.
Please.
Yeah, so when I get into my piece, I'm having some discussion about his mental health history. The case is about 2 years old. He has been dealing with being restored to competency for some time. And I just think he doesn't recall some of the things. So when we spoke about it, he doesn't have a memory of what or how or if he did anything that day. So
Okay.
It's not truly an Alfred plea. But as he kind of got around to earlier, he wants to say that he was sorry because he doesn't deny what the allegations are, if that makes sense.
Okay. I think I understand that. So, Mr. Fortson, you may not remember everything that happened in November, almost 2.5 years ago, but you're not saying it did not happen. You're just saying, gosh, I don't remember what was going on the MARTA train. Is that right?
Yes.
Okay. All right. But you've talked with your lawyer, Mr. Franklin, and you think that it is in your best interest to go forward with this plea. Is that true?
Yes.
Okay. Thank you.
Mr. Forson, how do you, in indictment number 18SC163983, how do you plead to the charges of robbery by sudden snatching, robbery by force, 3 counts of simple battery, and 1 count of obstruction of a law enforcement officer?
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Okay. Thank you, Mr. Forson. Your Honor, had we moved forward, had the state proceeded to trial, we would expect the evidence to show that on November the 25th, 2018, at East Point train station, the defendant entered the bus loop of that property and approached our first victim, Mr. Outler, while he was using his phone listening to music. He snatched his phone and ran. There was a description given of him that particular day, but he was not caught that day. 2 days later, on November the 27th, 2018, at 1400 Lee Street, Southwest Atlanta, Georgia, in Fulton County. That was at Oakland City train station. The defendant was on a train cart with another victim, our other two victims, Mr. Couch. He repeated to hit Mr. Couch in the head while he was attempting to take his phone and get off of the model train cart. Other civilians jumped in. One was able to get Mr. Couch back his phone. Officers were called to the scene. Before the defendant could leave the scene, he was apprehended by officers. There was another citizen that tried to jump in at some point when the defendant was hitting Mr. Couch, and he hit her. He pushed her. That's Miss Williams. She did seek medical attention, but everything is okay. She recovered. Meaning, I'm sorry, she didn't go to the hospital, but she sought there on the day when everything happened, when EMS arrived. She was checked out, but she was okay, so she did not have to go to a hospital or anything like that. But that's what the additional simple battery charges are for. And then the obstruction is from when officers tried to arrest the defendant and he resisted. Both the other, when officers arrested the defendant, he did have on his possession the victim from the first incident from November the 25th, robbery by sudden snatching. He did have his cell phone on his person. That phone was returned to that victim. We have spoken with our victims. The victim that was hurt the most in this situation was the elderly man, Mr. Derek Couch, which was the second victim who was hit upside the head to get his phone. When the state spoke with him, his position in this case is that he perceived some mental health issues going on with the defendant, and that for resolution for this case, he preferred him getting some type of help or some type of program, some type of supervision, rather than actually just being placed in jail. And he has been in jail for 827 days, or I think that was last week, but upwards 800 and something days he's been in custody. And so that's why we've been able to come to this negotiated resolution. I said we'll speak later as far as the MATA use, because the state wanted to ban the defendant from riding MATA completely. I didn't want the negotiation to fall apart based on that. So I kept trying with Mr. Franklin. We're almost there as far as the wording. We just hadn't gotten to it yet, because I want him to ride MATA for the purposes of his criminal cases, going back and forth for probation or any of that, but just not for the leisure of just being on the train. But that is, and as far as his convictions, Your Honor, he has 3 prior convictions. The last conviction is in 2014. Actually, it was 2, one out of Clayton County, which is a 2014 conviction, and one out of Fulton County, which is another also a 14 conviction, and then a theft conviction out of Clayton County in 2012.
And it sounds like one of those Clayton cases has resulted in a hold on Mr. Fortson, so he will be going to Clayton County next.
Yes, Your Honor.
Okay.
And that was one of the reasons why we couldn't get him into a program, but I'm sure Mr. Franklin will tell you about all of that. But that is all as far as from the state.
Okay. Thank you so much.
You're welcome.
Mr. Franklin, I'm happy to hear everything you want to share. 2 areas, please be sure you cover. One would be efforts you and your team have made to find a program for Mr. Fortson. I'm a little leery of simply saying get an evaluation and get treatment. The evaluation probably isn't going to tell us a lot we don't already know. So it's the treatment piece. And then the other would be how you see Mr. Fortson and Marta coming together or not while he is under sentence.
Okay. To address the court's first concern, to be completely honest, we did a request for a release of information with Mr. Fortson last year while he was still going through the competency restoration process. But once we became aware of the hold from Clayton County, we knew that the actual transport, the conflicting take him here or take him to Clayton County orders kind of leaves the person stuck in limbo. So in terms of actually taking that final step and saying, we've identified this program, let's try to get him into this particular program, we did not take that particular step. Second, given that we're in this time of COVID, we know that generally speaking, there was kind of this constantly changing status of how jails transported inmates back and forth to one another. So, for instance, if we had said, let's do drug court, or better yet, mental health court, where we would agree to it here, have him go to Clayton County, then reach out to his attorney and the probation officers there to try to say, hey, we have behavioral health court here in Fulton. Could you all agree to it and then return them back? My concern is that we would again find ourselves in that stuck area. And so we figured that that connecting him with the mental health probation officer was the most achievable sentence that would address the mental health concerns in any extent.
Does Mr. Fortson have a stable place to go? Is there a family member or someone where he'll be residing when he's released, or is that an additional unknown?
It's not unknown. To my understanding, Judge, he has been homeless for some time now.
Okay.
So
having him plug in with an ACT team is hard because we don't know what his address is going to be. So we can't say Grady ACT because if he's in East Point, that might not be the place to go.
Correct.
Okay.
And the other part that kind of led me here, and in other cases that are somewhat similar to this, I kind of harp on this more often than on the court. It's kind of heard me wax poetic about it before. When Mr. Fortson was arrested, my reading of the report, and certainly the reading of the interview that was conducted internally by the public defender's office, alerts me to the fact that he was pretty clearly suffering from some mental health situation at the point in time. And I think Grady would have been a great place for him to go on that day. The officer, for other reasons, because there were people who were actually physically hurt, brought him to jail. But the time that it took for him to be restored to competency, he's been in jail over, I think today is day number 866. And most of that has been either waiting to get to the pod to be restored or actually engaging in the restoration process. So I will agree that this is a probably less than optimal resolution, but I also think that Mr. Fortson's being in custody for as long as he has on these charges is also a balance that certainly weighed in my decision to try to go ahead and resolve.
That all makes sense. I worry for Mr. Fortson 6 months from now. He's going to be finished with his Clayton stuff. And unless the outcome of the Clayton revocation is a treatment program, I just worry that we will be ensuring a repeat of the cycle. And it's everyone's fault. It's no one person in this. It's that we don't have a good answer for poor Mr. Fortson. I don't know that this would have been a police, you should divert him immediately, given what you both have described. It sounds like an elderly man got beat around the head. And so I can understand why the police would say, we need to lock this guy up. But long before now, our system should have supported redirecting Mr. Fortson to treatment, not just restoration, but treatment. And we don't have that in place. And that's unfortunate. But I can say we're working on it. I spent several hours this morning on a conference where we are trying to get the city of Atlanta and the county of Fulton to invest more in crisis treatment for folks who are struggling with mental health issues. Sadly, we don't have that answer yet. Do you have other things you wanted to share on behalf of Mr. Fortson?
Not a great deal, other than the fact that I think Mr. Fortson did want to actually issue an apology. Mm-hmm. Again, my conversations with him, he didn't have a specific recollection of the actual events, but when we talked about it, like he was remorseful to the extent that he acknowledges that it was him. And so I would say that one of the benefits that has come from his being in custody is that he is diagnosed at this point in time, I believe. From what I was able to discern before his arrest, he had been undiagnosed schizophrenic. Mm-hmm. And he currently, I believe he receives a shot for that. I'm not positive, but he didn't recall taking pills for his schizophrenia. But the cogentin that he takes, cogentin is a medication that addresses side effects, like if you shake or something like that. My wife's a mental health professional, and I asked her about it, and she said it's kind of similar to what Benadryl would do if you take it for certain things. It addresses side effects. So I do believe that he is taking injections, but I'm not positive for that. So I don't want to over assert what I'm saying.
Okay.
But he does have a diagnosis. If he does come into contact with mental health professionals, I think through the record system, and they will be able to more quickly discern kind of what's going on. And certainly if he were to get in trouble again in Fulton County, they would be more accessible.
Got it. Thank you for sharing all that. Mr. Fortson, you've been very patient listening in, and you told me at the very beginning there were a few things you wanted to say. Tell me what you want to share about this case and how you're doing.
I wanted to say I apologize. I'm sorry, and it was a misunderstood apology before, but I really mean it. I ain't never mean to hurt nobody. If that's what happened, I never heard that somebody would hurt but me. And I just want to just say, if somebody family knew me, they should have told me not to do nothing I shouldn't have did. And I agree. I've been here a long time, and I try to make my bed up when I can, but it's still making me mad when I live in jail. I don't know how to get out on my own. And when I call my family, it's hard to get to them. And I stay with them. And I think
Where's your family, Mr. Fortson?
my family, my mom, my aunt, and my sister.
Are they in the Atlanta area?
Yes,
Okay. Mr. Fortson, you told me you take cogentin. Do you also get a shot every once in a while?
at Georgia Regional. Yes,
Have you gotten one since you've been back here?
no.
Okay. All right. Do you have any questions about anything?
I get bad vibes around certain people, and I probably was just mad that day when I grabbed the phone, or I didn't know if she was really calling the police on us because we were just running and having fun. But I wasn't by myself, but I still did what I did, and it came back to hurt me. But we don't stay in East Point right now. I think we moved.
Okay. Well, I appreciate you sharing that, Mr. Fortson. I do find that there's a factual basis for your plea. Based on what I've heard from the state, it sounds like the witnesses who were there could tell us what happened. I also find that your plea is what we call knowing and voluntary. A voluntary plea is one where the defendant, that's you, is entering the plea because that's what he thinks is the best way to move things along. It's not a forced plea. No one's forcing him to do it or threatening him to do it. Are you entering your plea voluntarily?
Oh no.
Well, I didn't describe that well. Has anyone forced you to enter this plea, or are you entering this plea because you and Mr. Franklin have talked about entering a guilty plea and you think that's the best way to move forward?
The best way to move forward was to accept the guilty plea.
Okay.
I will add this, Your Honor. I went to the jail this morning to visit with Mr. Fortson just to make sure that I could look him in the eye and make sure that I felt comfortable with his bearing and that he was still in a solid mental position as he had been on previous times that I visited. He presented consistently with how he's presented since he's been declared competent.
Okay. Thank you for getting that on the record. And I didn't ask the question real well. Mr. Fortson, it sounds like you have asked all the questions you want to ask. Let me tell you what I'm going to do in your case. I'm going to follow the recommendation that your lawyer and the prosecutor have put together. And so on counts 1 and 2, the robberies, the taking the phones, I'm going to sentence you to 5 years to serve 2 years. but I'm going to give you credit for all the time you've already been there, and you've been there for more than 2 years. So what that means is in the next couple days, you're probably going to be able to get to go to Clayton County to deal with, they need to talk to you about one of your older cases. So you'll get over to Clayton County and figure out what's next down there. You are going to be on probation for 3 years on this case. It'll be a special condition of your probation that you sit down and talk with the doctor about how you're doing and how you're feeling and how your mind is. And if that doctor thinks you should get treatment, maybe more of those shots or something like that, you'll need to do what the doctor says. I'm going to ask the Department of Community Supervision to assign a mental health probation officer to work with you. And then in terms of MARTA, I'm wondering, Mr. Franklin, if limiting Mr. Fortson to the buses rather than the trains might address or find that balance. Coming up with a limit of, well, you can only use MARTA for X and Y and Z, in some ways is complicated. One, for Mr. Fortson, but two, I don't know how you ever enforce that. But if being on the trains and sort of the temptation of just riding and moving from car to car is a concern, and I could understand why it's a concern. Buses get you everywhere the trains do, maybe not as directly, but they sometimes limit the risk factors that the trains and the train stations pose.
My initial instinct is that I don't think I have a problem with that restriction. I do, from whatever part of town you are, I do believe there to be a bus route that gets you downtown. And if you can get downtown, then you certainly can walk to probation.
Yep.
From anything that kind of gets to the 5 Point area. I do not have an issue with that. And I think it addresses both the concern that I have, and I'll let Ms. Hall speak for herself. But I think based on what she spoke to me about earlier, that probably, I'll let her speak for herself.
Okay. So Ms. Hall, the reason why I'm suggesting this is it's a simpler, brighter line rule. No trains, just buses. And then it's not, well, why are you on it? Or you could use buses and trains, but only in these locations. I think the more complicated we make it, the harder it will be for Mr. Fortson, as well as for probation to keep track of. Are you all right with that?
I am, Your Honor.
Okay, so Mr. Fortson, while you're on probation, it's okay to take a MARTA bus, but no MARTA trains while we're working through all this. So buses, yes, trains, no. You understand that?
Yes,
Okay.
thank you.
You're welcome. The last thing I've got, and I am sentencing you to something called the Probation Options Management Act. All that means, because I have to say it on the record, is that if you're on probation and you have a little problem, maybe you miss a meeting or something, you and probation will work that out. But if it's a big problem, let's say you get arrested again, then you and I are going to need to work it out. Okay?
Okay.
All right. If you were here in court, Mr. Fortson, I would have you sign your indictment. That's the charges that we've been talking about, and that's it right here. But you are out at the jail and I'm here. Is it okay if I sign for you, Mr. Fortson?
No, it's okay.
It is okay?
Yes,
Thank you. Then I'll sign for you. Mr. Franklin
Yes, sir.
and Ms. Hall.
Yes, Your Honor.
Great. Ms. Crawford, because Mr. Fortson is going down to Clayton to deal with matters and would be released from there, do you need to get info from him, or will that all be processed through Clayton?
That'll be processed through Clayton, and he also stated that he was homeless, so there's no information, but I did notate that he needs a mental health officer.
Great. Well, but I guess the other piece would be a reporting date, but you can't really give him one because we don't know.
When he'll be released. That's correct.
Got it. Okay. Mr. Fortson, I wish you the best. I hope you are maybe able to reconnect with your mom or your sister. Please take whatever medication the doctor tells you you should take. And I hope things turn out okay for you. All right.
all right.
All right. Good luck.
Take care, Mr. Fortson.
Thank you. Okay.
Thank you, Ms. Hall. Thank you, Mr.
You're
Franklin.
welcome.
Next, we have position 4, Mr. Michael Robinson.
Hey, Mr. Robinson, how are you?
Well,
I'm Judge McBurney. I don't think we've ever met before. I know a little bit about your case because I've talked with the woman who was your lawyer a bunch about it because I was trying to get you a trial. You have been in jail for a real long time, and you know that a whole lot better than I do. And so I tried to get your case on a trial calendar that actually starts on Monday. And I learned that your lawyer, Ms. Vargas, actually is no longer a defense attorney. She, about a month and a half ago, joined this office here in Fulton County. She is now a prosecutor. She's a colleague of Ms. Hall, so she's an assistant district attorney. That means you don't have a lawyer, and we need to get you a lawyer so that we can either get you a trial or that lawyer can try to work the case out for you. Do you and your family know that Ms. Vargas is no longer involved? Has anyone told you that, or am I the first one to tell you?
yes, Your Honor, I'm aware.
Okay. Are you planning on getting a lawyer, or should I appoint a lawyer to represent you?
It's in between right now.
Okay. Well, you're in the driver's seat. You're the one who is logging more days in jail until we can get you a trial. We cannot get you a trial until you have a lawyer. So if you want me to maybe check back in 2 weeks or a month, we could do that. And maybe by then you'd know, hey, my family's not going to be able to retain someone, and then I'm happy to appoint a lawyer. But I need to get that guidance from you.
You guys can appoint a lawyer. Because if we're able to come up with a lawyer, then I can still hire the lawyer. But as of right now, to move forward, you can go ahead and appoint a clerk, a lawyer, public defender.
So I'm going to have you say that again because they were making that really loud noise over on 6 South. Did you say appoint you a lawyer? Because you could always later on hire one?
Yeah, I was asking if, yeah.
Okay. We'll do that. Mr. Franklin, you are still on. Tell me how this process would work. There's no co-defendant, so I don't know if there's a conflict situation. And this may be Ms. Patel's case. It ends in a 2.
It would be mine. I actually, I'm familiar with Mr. Robinson and his mother. I turned over my file to Ms. Vargas at some point in time before she got off the case.
Okay.
She took over the case from me, so I have some familiarity. Haven't read it in a while, of course, but yeah, I have a relationship with Mr. Robinson.
Okay. Mr. Robinson, maybe you recognize Mr. Franklin. He's worked on your case in the past. What's the best way to proceed, Mr. Franklin? Obviously, you need time to see if Ms. Vargas can get you back your materials or you get a new set. I don't know. Ms. Beza, would this be your case or would it be Ms. Ocom's case?
This is my case.
Okay. So you and Mr. Franklin can talk about discovery and whatnot. It was trial ready. I put air quotes around it because it hadn't been nudged for a while, but there were no pending motions. Right. So when I reached out at that time, it was Mr. Pinion for the state and Ms. Vargas. They agreed it was ready to go. Just Ms. Vargas was in transition. So I'm not rushing you in any way, Mr. Franklin. I just want to know what the right next place to put the case is so that we are letting Mr. Robinson know his case is moving forward.
Yeah, so I would assume that Ms. Vargas has already withdrawn from the case and that stuff has been filed. And
I'm going to look it up right now. I hope she has filed that paperwork, but
yeah, I would assume that it was just
she filed it.
She filed it, so I would assume it's reverting back to me at this point. I don't think that I need to requalify him at this point because he's obviously been in custody for a long time. So
any resources he'd have would be family resources.
Yeah, I think I still have his mom's number. If not, I'll get down to the jail and speak with him next week and get a timeline about kind of what he needs or if he's okay just continuing with me. And sometime next week, I can send an email to the court and I'll courtesy copy Ms. Besa and let her know what the update is in terms of Do we need to put it on a status or inquiry to see if he has hired someone by a certain point in time, or if he's just going to roll with me?
Okay, I'm looking in the docket, and Ms. Vargas did file a notice of intent to withdraw, and she submitted a proposed order that I will enter that will get her off the case. Her name should not be on that side of the V anymore. And then if you, I guess you'll talk with Mr. Robinson, Mr. Franklin, but if it sounds like you're going to be in it, if you could file an entry again so that the system reflects that.
Yes, sir.
It reflects Ms. Vargas right now, and that's going to confuse everyone if the clerk's office is mailing notices to the DA's office for the defense. So I'll get her out of the case, and then we'll just look for your email saying, I need a month to review discovery as to whether there are going to be any motions, whatever time frame you ask for. But as you can probably do the math, Mr. Robinson hasn't budged from where he was when you were working with him. So we do need to figure out a way to move it forward. And you may recall it's a strange set of facts, and it may well be a case that is resolvable between you and Ms. Beza. I'm here. Pardon me?
I was going to ask Mr. Franklin, if you are going to be on this case, would you reach out to Ms. Vargas regarding her file and just getting it from her? And if she doesn't have it, then I'll reserve all the discovery on you.
Yes.
Let me know.
And one question for Mr. Robinson. Mr. Robinson, does your mom still have that number that starts with 55?
558.
Yeah, okay. I still got a number. I'll reach out to her.
That's pretty impressive, Mr. Franklin. All right, so
I haven't saved it in my cell phone.
just know he keeps things when you give it to him. Mr. Robinson, do you have any questions? I think you understand we're doing what we can to get your case moving again since Ms. Vargas found a different job. Any questions?
Can I ask you something in a private room right quick?
Yeah, if it's quick, let me
It'll be
move
quick.
you. No problem. I'll move you and Mr. Franklin into that private room. And then he's going to come see you soon, and you'll be able to talk as long as you want. But let me connect you guys since you're both in the same space. Hold on.
Okay.
Franklin. Okay, room 3 has just opened. 6 South and W. Devin Franklin. That tells me they're back, the magic sound. All right, Mr. Robinson, did you get cover with Mr. Franklin what you wanted to?
So this was the question, Judge. After he learned that Ms. Vargas was getting off the case because of her new duties, I believe, and I don't have Odyssey available to me on my laptop, but he stated that he basically filed a motion for a bond. Do I need to, will the court entertain it, meaning that I guess at the time he was unrepresented, and would the court allow us to request a date where it could be scheduled? If I just say if I verbally adopted, or do I need to file a brand new one?
You do not need to file. I see it here. It's odd. It has a lock on it, but I can open it. Hopefully you'll be able to when you get into Odyssey. But he did file a motion for bond. I mean, he was technically still represented in the sense that I hadn't allowed Ms. Vargas to withdraw, but she couldn't represent him by that time. And we should have a bond hearing. You don't need to file one. You just need to get with Ms. Beza and with Ms. Nelson to find a date that works for everyone. And you decide whether Mr. Robinson wants to be here in person, virtually, or doesn't even need to be plugged in. And you know that will accelerate or decelerate how quickly we can schedule it. I just need to make sure the state has a chance to get any victim family members in attendance.
Understood.
All right.
Okay.
Did you hear that, Mr. Robinson?
Yes, Your Honor.
Okay, so we'll hear the bond motion soon, especially if Mr. Franklin files that entry of appearance so he can actually represent you. And I'll get Ms. Vargas's name off the system for you as well. Anything else, Mr. Robinson?
No, Your Honor.
Okay. Thank you, Mr. Franklin.
Thank you, sir. You're welcome.
Next, you have position 5, Mr. Nelson Evans.
Hello, Mr. Evans.
How are you doing?
I'm okay. I'm Judge McBurney.
Yes, sir.
We've not met before. You have one of the oldest cases I've seen in a long time. But I think there's some good news from the state. Let me ask Ms. Hall, who's the prosecutor on the case, what she wants to have happen with your case.
Your Honor, the state is going to dismiss no process case, mostly due to the age. The defendant did serve time from 2005 to 2010, during which he could have served this sentence concurrent to that sentence, if that's the way we chose to resolve the case. We have tried to reach out to our victim in this case, to no success. That's been a couple weeks with my investigator. So the paperwork is complete. I just was trying to work with the language on that, but I'll send it over today.
Got it. So what did Mr. Evans spend time in custody for those couple years?
I believe it was in 1990, he was sentenced to 20 years in Walton County. And I believe that, so he was paroled out before then, and I think that this was a result of a revocation.
Okay, got it. So Mr. Evans, the state is going to dismiss your charges. I will sign some paperwork today that makes that go into effect. You should be released no later than tomorrow. So if you're not, you reach out to Ms. Patel and she'll start making sure we get you out of jail. Do you have a place to live?
Yes, sir.
Okay, good. Hopefully you've been staying out of trouble. This is something from your distant past that caught up with you. And I wish you the best with whatever's going on in your life, okay?
Yes, sir.
All right. That's it.
Last case, Your Honor, position 6.
Thank you. Are you Mr. Rogers?
Yes, sir.
How you doing?
Fine.
Good. You've got a case from 2014 that is on for a probation revocation. I don't have the petition in front of me, so I don't know why probation wants to have your probation revoked, but it sounds like your lawyer and the prosecutor have talked about it a little bit, and I'm going to hear from them, and I'll hear from you as well. So, Ms. Beza, I'm going to start with you. Why is the state seeking to revoke Mr. Rogers' probation?
A petition from the probation officer was due to a new arrest. It's a case where terroristic threats is charged. And that is the petition that I saw from the probation.
Is it an unindicted Fulton case?
Yes, it is an unindicted Fulton case, 20 CP 191180. There's no bond set on that case.
Okay. But we're going to deal. So what are we?
Yeah. So for the probation matter, Mr. Franklin, this is a 2014, I believe, case for probation. We decided to essentially revoke 30 days, which in sense is time served, as I believe he's been in 29 at this point.
Today is day 29, yes, ma'am.
Okay.
Still has the open, unindicted terroristic threats case where he's in on no bond on.
Okay, so I could revoke one day. Mr. Rogers isn't going anywhere until he sorts out his no bond situation on the 20 CP case.
Yes.
Okay.
Yes, essentially.
Do you know, Ms. Beza, is it the same victim across the two cases?
I do not believe it is the same victim. Let me check.
She needs to talk to 5.
It is not the same victim. The 2014 case is a James Hudson. The new case is a domestic violence case.
Okay, got it. So the state's recommendation is to revoke 30 days.
Correct.
Mr. Rogers, I promise you'll get to talk. I'm just working through each of the players here, and you're an important one, so I'll get to you. But the state's recommendation is, in light of the new arrest, and it's not contested he was arrested, he's not admitting to the conduct, it's just in light of the arrest, revoke 30 days.
That is correct.
And what about the balance?
He would continue to serve on probation.
Okay. Ms. Crawford, what is the balance for Mr. Rogers?
But he has 4 years, 5 months, and 29 days.
Okay. So I guess what I'm not trying to be slow on this one, but the point of having a revocation would be to have a revocation that has consequences for the new alleged conduct. So either the state says we want to have an evidentiary hearing, and with a lower standard of proof, they prove that Mr. Rogers threatened whoever the alleged victim is in the 20 CP case. And then there is a more meaningful revocation than one that is effectively time served. I'm confused as to why this is how we're sorting through this, because it kind of defeats the purpose of probation even bringing a warrant when someone catches new charges and they're on active probation. So, Mr. Franklin?
Yeah, so I will say that, and I'm not sure how much of this Ms. Besa will disagree with, or if she even has the basis to disagree with it yet, because I knew it was gonna be my case a bit longer than she knew it was gonna be hers. The complaining witness in the 20 CP terroristic threat case is a woman who he is still in a relationship with. Ms. Besa, I'm not sure she's had a chance to speak with that woman yet, Ms. Timms. I spoke with Ms. Timms. She expressed that even at the point in time that everything was going on, that she did not want to prosecute, but because of the way that Mr. Rogers was reportedly behaving that day, the officers felt they needed to take him in custody. Specifically, what Ms. Besa was able to find is a report that I've not yet received, but she's read to me, that basically says that Mr. Rogers and Ms. Timms were having an argument. Someone else, it appears, is the person who called the cops. cops get to the scene and Mr. Rogers is agitated that, you know, they are getting involved in this, you know, personal kind of argument. He is alleged to have made some threats as the cops are taking him into custody.
Threats to Ms. Timms, not to the police officers.
That's my understanding, yeah.
Okay.
And although part of the reason it certainly hasn't been indicted is the shutdown of the grand jury for the better part of a year, I also think that under the new regime, if it's reviewed and investigated before it gets to the grand jury, that there is a possibility that it may be no bill or they choose not to go forward. I don't want to overstate that. I know Ms. Baser feels differently about the character of the allegations than I do. But I think that, you know, it was on the calendar, it was before us, and there are also other charges that are pending. He has a hold from another county, and there's also a drug case that is a more recent arrest. So I think he was originally arrested for this jailing on this drug case that is about a month old.
What? Yeah, that means you can have everything.
Hey, who's on the iPhone?
You'll have it. Come on. Hurry up.
All right, I'm just gonna remove them.
I'm starting to think that's my baby mom because she hit the link to be in court with us there.
Okay.
Okay. So I believe that, I forget where I was.
Well, you said there's some drug charges out there as well.
So he was arrested on some more recent drug charges. I think the warrant then pops up once he's brought back into Fulton County. So there's this 21 CP cocaine with intent case.
Mm-hmm.
This pops up once he's arrested on that. And it was just on the calendar for us to resolve and deal with it. So in my opinion, my request to Ms. Baser would be that it's not a case that I would argue whether the threats that were made are sufficient threats based on the fact that the complaining witness reportedly doesn't feel threatened by them, and whether it's a case even worth going forward on. But that's certainly just my opinion. And he's already served like 30 days. So, just a moment, Mr. Rogers.
So, Mr. Rogers, what do you want to tell me?
I was just trying to say that she was trying to fake him, and though that the new case, that was a codependent case. It's just because I was around, they just charged 2 people for 1 charge. So I guess my codependent was going to take his charge whenever we do get in court for that. So I won't have to worry about that at all.
Okay. How long have you been in, Mr. Rogers?
Locked up since February the 9th.
So, this is why we were saying 29th days. It's about, okay, got it. And you got picked up on this or for the cocaine charge?
All together.
Pardon me?
All together.
All together. Okay.
Yes, sir.
Ms. Beza, what did you want to add?
I wanted to add that probation, I don't believe, filed revocation for the February drug charges. So as my understanding, we're here regarding the terroristic threats case. I do believe the state will be able to prove that case, obviously beyond reasonable doubt. However, my reasoning for 30 days was no bond is set on all of the cases, on the cocaine case and on the terroristic threats case. So we wanted to just settle the probation matter.
Okay, well, I hear you on that, and I think I understand.
Unless I thought about it all wrong.
Well, so it's not an issue, it's a procedural thing, and we'll just need to get comfortable how we're going to handle revocations in this division. Okay. If I were to revoke Mr. Rogers for 30 days or 100 days or 2 days on this petition, and then later he entered a plea or went to trial and was found guilty of the terroristic threats, okay. You could not seek to revoke any more time for that situation. So you'd be using up the 30 days for 30 days he's already served. You're correct. This petition only talks about the terroristic threats charge. So there could be another petition coming that alleges Mr. Rogers violated his 14 SC probation because he got arrested for having cocaine. But it sort of isn't the purpose of bringing a probation warrant. I know you didn't bring it, probation did, but I'm now speaking on behalf of probation, I guess. It's not in the way of anything right now. There's no bond on the terroristic threats. There's a hold from another county. So probation isn't what's holding Mr. Rogers back from doing any of the other things he may need to do. It is effectively saying the arrest for terroristic threats and those charges were of no consequence to probation if it's a time served. And if later on the case is of the merit you think it is, Ms. Beza, there isn't a way to say, and we're going to revoke some of your time for that as well, because the 30 days will have, or 29 days or whatever it is, will have already been revoked. So I don't know that I'm going to do anything with it now. It seems like maybe probation ought to consolidate things so that there is a single petition that sets forth the various alleged violations of probation in the 14 SC case. One would be the arrest and the terroristic threats, and the other would be the more recent arrest. Then everything's under one umbrella for us to deal with if we need to deal with it. Those charges may get dismissed, they may get indicted. This would follow that if they end up getting indicted.
Try to burn me your phone.
Excuse me, sir. I ask you a question. I'm currently right now on bond for my terroristic threat, sir. I bonded out for terroristic threat. I'm still currently on bond for that right now. And I do have a bond for my charges right now, which is $18,000.
Okay, well, let me, that changes, thank you for flagging that. Let me look up the terroristic threats case.
I hear my fiance on the phone. That's her. That was her just doing the talking.
And she needs to mute her phone. If she,
okay.
I've kicked her out several times because it's real loud.
Okay. That's what the case is about. The terroristic threat. It's about her, and she's on the line right now.
I understand, but we're not working through the substance of it today.
Yes, sir. But I'm
okay. I see you do have a bond. Okay. I didn't have that piece of information. And so if Ms. Beza is comfortable with what she and Mr. Franklin have talked about, you actually won't be held in connection with the terroristic threats piece of this. The new drug charges, you may be held. The having to go to another county may hold you, but I thought you had no bond on that.
I think when Ms. Beza made that mention, she was referring to there's no bond on the probation hold, not on the actual case.
Okay.
No, I thought there was no bond on the case, but I read this in Odyssey incorrect, I believe.
Yeah, there's a bond, and he's made it for the terroristic threats. In April of last year, a $5,000 bond was set, and he posted it. So I'm going to get out of the way, and I will go along with what was negotiated because it's a slightly different procedural posture. I'm going to revoke 30 days, Mr. Rogers, because of your arrest in the terroristic threats case. And I will reinstate the balance. So you'll have a little less than 4.5 years left on this one. You've got bigger fish to fry in this other county. And then these drug charges, the 21 CP matter. But this probation warrant is one you can check off now. It's one fewer things holding you in.
Judge McBurney.
Yes, ma'am.
Sorry to interject, but I was doing a little research. Could you check your email? There looks like there was a petition, an updated petition, but the officer from probation did not have him to sign it.
I've been signed it. I had it right here. I have all the information right here. I've been signed my petition for both cases.
Hold on, Mr. Rogers. Hold on, Mr. Rogers.
I'm sorry.
You all right?
Okay, I see. So I have a petition in front of me that I'll send to Mr. Franklin as well and Ms. Beza. And it alleges 2 violations. One we're talking about, the April 11th offense or arrest for terroristic threats, and February 9th, 2021 crossing guard lines with prohibited items and possession of cocaine. So it sounds like to me, and Mr. Rogers, don't say anything in response to this, he got picked up on the probation warrant and had drugs on him when he went into the jail. But that there is a petition to that effect that I have signed. I signed it on February 16th. That's not what got emailed to me a few minutes ago. What got emailed to me was the old one that only had the terroristic threats on it. So we collectively weren't real organized for today's hearing. I'm wondering if it makes sense to get Mr. Rogers back soon, but so that we're dealing with the whole thing. Because if there is a warrant for him in the system for the new petition as well, which I've signed, we're only resolving a piece of it.
Yes, I agree. I would ask for another date, especially so I can, now that there's another case added on this probation matter. I have not seen the petition. It's not in Odyssey, I don't believe so.
Yeah, Ms. Basin and I both kind of searched Odyssey at the same time yesterday, trying to figure out what the basis was. And
yeah,
all we were able to find was the document that was attached to Mr. Rogers' booking screen that was for the just for the terrorist threat case.
Got it. Well, I've just forwarded to both of you the new petition that has both sets of charges on it.
I received it, Your Honor.
Okay. So my thought is we get Mr. Rogers back here on our next available calendar. And it may be that we have the same conversation, but I don't know that Ms. Beza is in a position to talk at this point about the 21 CP. That wouldn't be her case, but it doesn't mean she can't talk about it, but she just needs to be able to do a little more research. But I wouldn't be able to, I mean, I would be ruling only on one of two warrants that are out there. Mr. Rogers.
So you're saying that my probation, it can be revoked 30 days reinstated for both or once? Like,
No, I'm not saying that. What I'm saying is we're gonna pause things because there are two petitions out there, and the one that I had in front of me on the screen that I thought we were dealing with is the old one that only talks about the terroristic threats. And I now understand you got a bond on it. I understand why the state is saying, shh, well, they didn't think you had a bond on it, but you do have a bond on it. And so you actually, that wouldn't be weighing you down.
I'm sorry. So can I make
go ahead.
So can I make my bond on my new charges and go into Clinton County and resolve that?
I don't know if you can make your bond on your new charges.
If I make my bond, will probation still hold me here?
Yes, because we need to, the state needs to figure out what it's going to do with the new petition, and Mr. Franklin needs a chance to talk to you about the new petition. So I know you're anxious to be other places, but you have a lot of business going on. Do you know the county you need to go to, Mr. Rogers?
There's just Clinton County, but it's a codependent cases that there's two people charged on one charge, and I'm not gonna be held. I'm not gonna be held accountable for it at all. You know what I'm saying? I just want to seek out, make mine, and report to probation first time I get out. Like, I have a misdemeanor in Clinton County. I'm not worried about that. But I just want to know, like, can I be reinstated so I can make mine on my charges so I can report time I get out to probation? You know what I'm saying? Whatever. I'm very innocent on the. I know I can't just I don't want to talk about the new charge.
Right. You shouldn't talk about the new charges right now. You should talk about those with Mr. Franklin.
Yeah, it's a codependent case, and it just went further as a burn here.
All right. So what we're going to do is get back together soon. But we need to make sure we're taking care of all your business at once and not in little pieces, because then you'll keep thinking, hey, I'm done, and you're not, and there'll be something holding you in. So everyone has the right petition now, and I'll work with Ms. Nelson to get this on another calendar real soon so we can work through it. All right?
So, like, would I be in court within the next week? Like,
that it will be in 1 week, but it ought to be in the next couple weeks. Yes.
So it won't be.
Meantime, Mr. Franklin will be able to talk to you.
Yeah, it's complicated. I think I understand what the judge is saying now, Mr. Rogers. It's different than what you and I discussed on the phone earlier this week, or what I discussed with Ms. Timms. So I'll have to come and re-explain that to you, because we might have to go through it a couple of times. It's quicker. It's more than I can probably explain.
I
in
just
2
want
minutes or so right
to
here.
know one question. Like, when would you like predict me to be in court in my next court appearance?
That's not up to me. That's up to the case manager. I have to figure that out.
Yep. I'll talk with my staff today, Mr. Rogers, and we'll get you back on there soon, okay?
Yes, sir. So is that first one reinstated the service control?
Well, the first one doesn't really matter because the second one covers both things, the 2 petitions. They really ought to be consolidated, so we're only talking about one, which I think was the purpose of that second petition that I signed a couple weeks ago. All right, I'm sorry for the confusion. We're usually more on point, but you've been you had a few things going on, so there were a few things rattling around. All right, thank you, Ms. Beza. If you could make sure that whether it's a combination of you and Ms. Hall, that you collectively are in a position to talk about Mr. Rogers' situation next time we get him here. We know it'll be Mr. Franklin, and so I just want to make sure that the state has developed a single point of view as to what ought to happen with Mr. Rogers.
Yes, Your Honor. We've already started discussing it briefly via text.
Excellent.
So.
All right. Ms. Crawford, anything else we need to know about Mr. Rogers? If there's a third petition, we ought to get that as well.
No, Judge, I was just searching to see if they have completed it. So I'm reaching out to the probation officer now to see if I can get the copy where he has signed it and get it e-filed and sent back to you.
Okay, because he is saying he signed it. He was
That's correct.
Adamant that he'd signed it, which is good. That's not going to stop us, but that should make things move faster.
Okay, that's it from me.
So,
And Ms. Besa, did you get my email and my telephone number?
I
put
did.
it in the chat. Okay.
Yes, I did. Thank you.
Franklin, can you call my girl and let her know, or can you answer the phone for my girl and let her know what just went on?
Mr. Frick, you got that?
Yeah.
Great.
Yeah,
She's pretty persistent with the phone. My guess is she'll be calling you when she gets off this.
All right, thank you.
All right. Well, thank you, Jail. I think that's it.
Yes, thank you.
Appreciate it. Thank you for moving Mr. Turner up from 1 North.
Are you welcome? No problem. Have a good one.
You too. Bye-bye.
All right, thanks.
All right, folks, I think that is it for today. We've got a plea and arraignment tomorrow afternoon. They're not particularly new cases, man. They're 20 SC cases. They're not 21 SC cases. But I raise that only because I assume fairly soon we will start seeing cases flowing from these 2 grand juries that are showing up almost every day. Tomorrow afternoon should be pretty brief. We'll handle those. And then Ms. Nelson will work on getting somewhat routine plea and arraignment calendars as we start to see the new inflow of cases from these grand juries. Ms. Hall, anything else from your side?
Nothing further from the state, Your Honor.
All right, Ms. Beza?
Nothing, Your Honor.
All right, thank you. Mr. Franklin, anything else?
Sir.
Okay, sorry about the Rogers confusion, but I think we ought to try to resolve it all at once rather than in 2 pieces.
Judge, can you stay on? I just have a couple questions for you.
Yes, ma'am.
Thanks.
All right, bye, everyone.
Thanks. Bye.